Good morning, Your Honors. The matter before the court this morning is the case entitled Execusuite LLC versus Mitchell Cable et al., case number 25AP097. Representing the appellant, Execusuite LLC, is Attorney Brannon. Representing the appellee, Mitchell Cable et al., is Attorney Monahan.
Mr. Brennan, you understand you have 5 minutes, and we'll give you a warning with 1 minute left to go, and you just identify yourself and your client, please, before you begin.
Yes, thank you, Justice Cohen. May it please the court, my name is Barney Brannon. I represent the plaintiff below and the appellant here, Execusuite LLC.
All right.
So, given the shortness of time, I won't spend a lot of time reciting the basic facts here. I'm sure the court's well familiar with them. Instead, I want to go first to an argument that the appellees made, which, though the court below did not expressly adopt this argument, I think that their argument perfectly highlights exactly where the clear error lies in the trial court's decision, both with respect to the issue about the court's interpretation of the abandonment statute, which is 9 VSA section 4462 under the residential landlord-tenant law of the state, and second, with respect to the court's interpretation of the standard of whether or not the officers, the defendants in this case, acted in bad faith or were patently unreasonable in their actions. The quote from the appellee's brief is this. It's from page 8 of their brief. It says, "The existence of a property interest is contingent on compliance with statutory procedures, such as the need to obtain a judicially issued writ of possession." We submit, members of the court, that is just fundamentally wrong. That property owners do not, essentially what the appellees are arguing is that property owners do not have any interest in their property unless or until a judge, or in this case, police officers, determine that they actually have a property interest. And that, in this case, depends upon the issuance of a judicially issued writ of possession. We submit that is fundamentally upside down in terms of both our constitutional scheme and in terms of the particular application of the statute at issue here, which is the abandonment statute 9 VSA section 4462. With respect to the court's interpretation of the abandonment statute, essentially what the trial court did in this case, which we submit as clear error, is that it read into the statute a requirement that plainly is not there. And that is a requirement that the tenant has to agree that the landlord has a right to retake possession of the dwelling unit in question, or at least that the tenant not affirmatively disagree, that is, actively disagree. And if you read the statute, we submit that there is clearly no such requirement. And furthermore, we submit that the court below erred when it essentially allowed 4 municipal police officers to arrogate to themselves the judicial authority to make that determination. So I want to address each of those briefly, and I am aware of the time. The first is that what the court has said, and it's in the court's decision, which is in the printed case, of course, at page 6 of the printed case, is that the idea of the abandonment statute is that the tenant must agree that the landlord retake possession. I won't belabor the argument because we've made that in our brief, but I think it's clear that there is no such requirement in the statute. Secondly, the appellees have argued in their brief, and this is
Mr. Brannon, you have 1 minute. You have 1 minute remaining.
Thank you, Justice Cohen. The appellees have argued in their brief, and this is a clever argument, that what they did could not have been patently unreasonable if a trial judge subsequently agreed with them. But the problem is, as we submit, that the trial judge committed plain error when it subsequently agreed with them. And moreover, what the judge overlooked in the particular case of the behavior of the defendants here was that the determination that they made was a judicial determination, and one that we submit that should have been submitted to a jury. And in particular, and in closing, because I'm aware of the time running out, we would ask the court to turn its attention to two critical facts which were undisputed and are laid out in the printed case at page 61 in paragraphs 6 and 7 of the document that was prepared by the appellees as the reconciliation of the parties' positions.
And Mr. Brennan, just finish up your argument, please, if you wouldn't mind.
Those were the main points that I wanted to make. Thank you, Justice.
All right. And the Chief Justice or Justice Waples, any questions for Mr. Brandon before?
Oh, thanks, Justice Cohen. No questions.
Justice Cohen, thank you, Chief. I just have one question. Mr. Brandon, again, that citation in the printed case, you said is page 61, paragraph 6 and 7?
Yes, Justice Waples.
Okay. All right. Thank you.
Monahan, you have identify yourself, identify your client, and you have 5 minutes for your argument.
Thank you, Mr. Justice Cohen, Justice Waples, Chief, may it please the court. I am Brian Monahan. I represent the 4 municipal police officers who were defendants below in this case, and they are the appellees here, Officers Cable, Clifford, Ebbighausen, and Joshua Reyes. This case is really about an effort by an experienced landlord who owns and manages numerous properties in the Upper Valley and in central Vermont to basically recast fundamental bedrock Vermont landlord-tenant law. Really, if this court were to accept the appellant's arguments, a landlord could simply call the police and engage police officers to be landlord assistants to assist in extrajudicial evictions without having to go through the fundamental, well-known, well-tested proceeding to obtain a writ of possession. And that's exactly what the appellant is asking this court to do here. We know that this court has certainly heard about the abandonment statute many times. It's got 3 elements that the landlord must satisfy. There's got to be circumstances that would lead a reasonable person to believe that the dwelling unit is no longer occupied as a full-time residence. The rent must not be current, and the landlord must have made reasonable efforts to ascertain the tenant's intentions. And the only piece of that the landlord was able to satisfy in this case was that the tenant was not current in paying his rent. The tenant had communicated clearly in writing and verbally, and it's in it was captured on camera. It's part of the record in this case. He clearly indicated that he was not relinquishing his tenancy. And we do know that he does not appear to have been living there, but he did maintain his possessions there. And that is something that he is allowed to do under the abandonment statute. And he made it clear to the landlord that he would not be abandoning the premises. So it's clear to us that this effort by the appellant here was actually an illegal eviction under section 4463. And 4463B states no landlord may directly or indirectly deny a tenant access to and possession of the tenant's rented or leased premises, except through proper judicial process. And in this case, the appellant landlord sought to simply avoid the burden of going through judicial process to obtain the writ of possession. The landlord sought to engage with the police officers and have the police officers escort the tenant out of his properly rented premises. And the police officers appropriately refused to do that. They relied on their training. Of course, police officers are regularly called to landlord-tenant disputes, and it is their obligation not to adjudicate, which is the word that the appellant has been using in this proceeding. They didn't adjudicate anything in this case. They preserved the peace. And they allowed the opportunity, the real estate, if you will, for the landlord to simply go to court to obtain the writ of possession that we all know it's properly required to obtain in order to effectively legally evict a tenant under Vermont law. Even let's be clear about what the appellant knew and had the obligation to do. The landlord has to put itself in the shoes of a reasonable person. And a reasonable person in this instance would understand from the two separate emails that the tenant provided to the landlord, as well as the verbal conversation that the tenant had with the landlord's representative on scene, that
Mr. Monahan, you have 1 minute remaining.
Thank you, Justice Cohen. It was clear, it should have been clear to the landlord, if the landlord had been behaving as a reasonable person, that the tenant had not abandoned the premises. And then finally, I'll close by talking a little bit about qualified immunity. Qualified immunity, as we all know, provides a protection for governmental officers who are required to act in difficult situations that are not as comfortable as our homes or our offices as we are today. And the analysis, as we know, is not that we should be able to carefully analyze the acts of these officers from the comfort of our homes or our offices. It's that we have to put ourselves into the shoes of these officers who are pressed in difficult, high-pressure situations to make decisions in the heat of the moment. And that's what these officers did. Even if they had been wrong, qualified immunity still protects them if they had a good faith belief that what they were doing was correct. Thank you, Your Honors.
All right. Any questions for Mr. Monahan from the Chief Justice or Justice Waples?
No, thank you, Justice Cohen.
No, thank you, Justice Cohen.
Can you call Dale, please call the conclusion of the case.
The next hearing for the court